This third panel, as I've enjoyed this conference, I see it as something of a possible resolution of a tension that's arisen between the first and the second panels. The tension that I see between those two panels is whether, given limited resources, it is better to expose our students to more context and more perspective in a generalized survey course that examines those big questions and those big themes, but then of course that lacks some coherence for our students. Or to instead, sort of the idea of the second panel, instead do you focus comparative law on a grounded introduction with a subject-specific or a country-specific approach that is then infused with elements of those larger themes, that larger context. This panel, I think, suggests something of a resolution, at least in certain contexts. And the idea is to leverage the learning environment to do some of the teaching of that larger context for you, leveraging the learning environment. Because when students are learning law in another language and or learning law in another country, the education about that larger context may occur by osmosis as opposed to occurring by readings that may be inaccessible to our students or through class discussion that is too generalized to be meaningful for them. Our speakers, our three panelists here, have done very interesting and labor-intensive work to benefit students' understanding of comparative law. And it is important, or I want to emphasize then, that these are not just accomplished scholars, but they're also dedicated teachers who've done a lot of work to be successful teachers. I would also note that they're brilliant, creative, and nice people, which is fun. The three panelists, I'm going to introduce all three so that I can limit the disruption of the flow of this panel. First, Raquel Aldana. Raquel is a professor here at Pacific McGeorge. She is the co-president of SALT. She's also the founder and the director of our Inter-American program, which is committed to educating bilingual and bicultural lawyers. So Raquel Aldana will speak first. Second will be Vivian Curran. Vivian is a professor at the University of Pittsburgh. She is the founder and director of Pitt's innovative Languages for Lawyers program. She's also a past secretary of our society and a former book review editor of our journal. And the third speaker is Colin, a professor at the University of New South Wales. He's a member of the Executive Council of our society, and among his many publications is his book that he's co-authored with Mary Ann Glendon, the Comparative Law Casebook. So, without further ado, Raquel Aldana.
Good morning. That was such a nice introduction, Thom. Thank you. And I also wanted to acknowledge Frank's really amazing contribution to our law school in many ways, and also thank you for inviting me to be on this panel. So I have to confess that I was feeling like a bit of a novice speaking to a group of distinguished experts until yesterday, when you all sort of revealed that despite the number of years that you've been doing this, you still have a number of questions. So that made me feel a bit more at ease. I have only been teaching comparative law since I joined Pacific McGeorge about 4 years ago. But as Thom explained, I've also directed this Inter-American program, which has the modest goal of preparing U.S. law students to be able to become cross-culturally competent lawyers to work in Latin America or with Latinos in the United States. So of course the course on Latin American law is quite conventional in that it takes place in a U.S. classroom. And the Inter-American program has a study abroad component that takes place in Guatemala, and it is also bilingual and has experiential components. So what I want to do in my talk today is draw lessons from each of these vastly different approaches to teaching comparative law to suggest what I now believe are best practices, both in terms of outcomes for teaching comparative law and best means of achieving those outcomes. So let me begin with another confession, which is that I have taught comparative Latin American law on our McGeorge campus only once. And the reason for that is because I have avoided teaching it twice. And the reason I have put it off is that I just didn't feel that I have had the time to adequately adapt the course to satisfy my expectations. It was most definitely the hardest course I have ever been asked to teach, even though I did it with a tremendous amount of enthusiasm and certainly passion. But the whole time I taught it, I felt like a bit of a fraud. I ended up supplementing the whole casebook the only casebook available to teach Latin American law with a bunch of additional materials, and then I used films, and then I felt like the course became this hodgepodge of lessons in history, political science, sociology, and law about a bunch of countries, when I am neither a historian, nor a political scientist, nor a sociologist, nor frankly a lawyer from any of these countries I was teaching about. I'm a US trained lawyer, though of course I was born in Latin America, and I came to the US at a young age, at age 10. And my own experience with Latin American laws is that I was reintroduced to Latin America's legal institutions as a young lawyer from a lens of failed nations and failed laws in the context of human rights litigation before international human rights tribunals. And then as I became a scholar of Latin America, I became interested in understanding the failings of law in my mother continent. And my critical lens led me to reconsider the preeminence of law in fixing the structural social inequality that made much of law irrelevant in many Latin American countries. So I rejected the approach to teaching Latin American law that specifically tried to place its origins in Europe without acknowledging the legacy of colonialism that made even the liberal tradition of law that would later inspire independence as a largely elitist enterprise, proudly disconnected from the masses. To be honest, I did not know what to do with the chapters in the casebook devoted to Roman law and European civil law. Initially, my instinct was to just skip those chapters, and yet that seemed somehow blasphemous. So I assigned them and quickly regretted it when the day came when I had to teach the subject. So what I did was to connect the readings to Hugo Chavez's Bolivarian Revolution. It gave me a chance to explore Bolivar as a bit of a historical figure and to extrapolate from this now distorted historical image that he represents how he became from an elitist liberal to the figure of a populist so-called leftist revolution in Venezuela. This approach gave me an opportunity to introduce very quickly topics of legal imperialism through law and development movements in Latin America, and the role of U.S. international financial institutions, the U.S. international financial institutions and the like, to push for a globalized agenda of free markets in the context of weak states, largely irrelevant laws, severe income inequality, and grave problems of human insecurity. Yes, and I did teach law, I promise. We cover the constitutional revolutions of Latin America as a byproduct, in many cases, of civil strife. We discussed the amparo in various countries of Latin America, and specifically I focused in the use of the amparo in Argentina following the financial crisis in the 1990s as a way to fight recovered factories taken over by the workers during a time when Argentina faced 40% unemployment, and in the absence of a state to provide unemployment benefits or to rescue failed businesses, which is what was happening here in the United States. So it was a very different type of law and responses by the state that gave us an opportunity to explore different conceptions of property and how even those conceptions can transform in the context of social economic crisis. It did occur to me that maybe I should have titled the course Latin American Comparative Law from the Left. But actually my approach was not ideologically motivated. I am not even clear I fully grasped what the left means in Latin America. And from my perspective, it too has largely failed to address the structural problems that plague Latin American nations. But I was motivated in teaching the course, as I am in all of the courses I teach, and what Patty described yesterday as a search of how law can advance a just society. In that sense, starting place, it seems to me, in Latin America has to be a reorientation of law away from U.S. and U.S.-centric perspective to a Latin American-centric one. This required a more honest discussion not only about European colonialism, but also U.S. imperialism and globalized neoliberalism. But what exactly were my desired outcomes? Well, I wanted students to learn some basic important components of Latin American law that were different from the United States, such as, for example, the very different role that social and economic rights plays. I also wanted students to appreciate the importance of studying law in context, such that they should consider how history, culture, the relative strengths of legal institutions, and the state, and the socioeconomic factors play in evaluating the legitimacy and the effectiveness of law. And I also wanted somehow for students not to caricature Latin American law and legal institutions as simply too corrupt, too illegitimate, too weak, too formalistic, and on and on. This was quite tricky, and I'm not sure I successfully avoided it. When being critical, how do you keep from breeding cynicism when students have nothing else to counter the critique? Even worse, how do you keep students from developing a sense of U.S. superiority in the rule of law and inadvertently somehow perpetuate a rescue approach of the well-intended and yet largely ineffectual U.S.-centric rule of law movements in Latin America? In some ways, I was lucky in avoiding some of the pitfalls. The class was really small. It only appealed to 8 students, 4 of whom had spent 2 years in Latin America as LDS missionaries. Thus, I feel I could aspire to a deeper understanding of law in social context without completely caricaturing Latin America. But the missionary instinct was really strong in all of the students. And I do think that they walked away feeling like they needed to fix Latin America. And in that sense, I failed miserably to be an advocate for inspiring respect and even admiration for Latin America, which I certainly have. And I think it's this fear of creating the next wave of law and development reformers in Latin America that keeps me from wanting to teach the course again, at least not in that way. In the classroom, the students had no opportunity to experience firsthand a more nuanced appreciation for Latin America. And I frankly worry that in a larger seminar with students with little exposure to Latin America, the problem could be a lot worse. Upon reflection, in preparation what I would say to you today, I realized that part of the problem is that my expectations were too grand and too unrealistic to achieve in a classroom. However, I don't think any of these goals are too grand when taught in context, which to me means meaningfully connected to the more nuanced reality of Latin America, where law's grandeur and shameful failings coexist, where law heroes counter the forces of corrupt officials, where hope and courage is often, though not always, brighter than despair and fear. So I want to take just a few minutes to explain the design of the Inter-American program and let you be the judge of whether you think I'm still delusional. We chose to have a program in Guatemala despite some significant security concerns because it is a country that is more representative of the Latin American reality today. It is a country paralyzed by fear and insecurity, affected by moral decay of too much greed, where children die of simple malnutrition and diarrhea even though there is great wealth, and where, from my perspective, one of the ugly faces of globalization is the unchecked multinational, which continues to exploit the failings of largely weak and unrepresented states. As you can imagine, our students who participate in the program are exposed to all of this, both in and outside the classroom. Despite the incredible beauty of Guatemala and the fact that we do significantly shelter our students while in the country, navigating safety alone for our students is jarring. They feel trapped, restricted in their freedom. And after a while, the impossibility of simply avoiding poverty weighs heavily on all of them. However, I feel the program provides a sufficient counterweight to the story to provide a much more robust experience of Latin America. Much of this has to do with program design. For one, our program is bilingual, and we either teach students who are proficient in Spanish comparative law courses in Spanish, or we immerse them in Spanish and teach them legal Spanish courses and comparative law courses in English, with the message being very clear that true cross-cultural competence requires language proficiency. I can tell you that simply the experience of having to learn law in Spanish alongside incredibly accomplished Guatemalan students is incredibly disarming for our U.S. students and allows them to experience what it feels to be vulnerable and disadvantaged, even in a small scale. We also co-enroll Guatemalan students and lawyers in the program and invite Guatemalan professors and lawyers to teach in the program. This is key, as these students, lawyers, and professors provide the counter-narrative of legitimate struggle, pride, survival, and hope for their nation that I sorely lack in the U.S. classroom. And we provide experiential learning opportunities for students through field placements in the country with government, international organizations, commercial associations, and human rights groups. This is invaluable not only to teach students useful skills of being a global lawyer, but to uncover the sophistication of law and legal institutions in Guatemala, and more importantly, the heroic lawyers, whether in government or in civil society, some of whom are literally willing to die to try to defend the country. I recently wrote an essay about the program which I titled Transforming Students, Transforming Self, the Power of Teaching Social Justice Struggles in Context. The essay explores how the poor indigenous communities in Guatemala have experienced Canadian mining. The essay also explores the theme of the importance of conscious personal experience for learning social justice. Our students who have worked with NGOs in their struggles against unfair mining practices learned a great deal about the promise and limits of globalization for indigenous communities in Guatemala. In general, their involvement uncovered a grassroots activism and a bottom-up movement of resistance, largely dependent on transnational and international legal norms and strategies that failed to provide a satisfactory remedy to the community. Students experience, for example, how the confusion of legal norms and the decentralization of accountability through development of so many new and overlapping laws and institutions to address transnational problems were unfortunately adding up to less than the sum of its parts in the struggle. While these lessons were not hopeful and sometimes frustrating, this is not all they learned. For one, I do not think a single student who has participated in the Guatemala project has walked away without feeling proud of the legal profession and the role of lawyers in promoting social change. For many of our students, this was such a unique and rare gift. The cynicism against lawyers and the disrespect for the legal profession and popular culture can make most students forget the heroism, dignity, and worth of lawyers to create significant change in the lives of individuals. In Guatemala, however, the intractable problems that society faces made many of our students wonder why lawyers stayed, why they woke up every day to create change, why they did not give up. This was especially true of the students who worked with the environmental justice NGOs that taught our students so much about the courage and dignity of our profession. Through the experience, some would also discover their own courage and their profound humanity to connect very deeply with people from so very different from themselves. So I have to conclude by saying that despite how challenging it has been to direct the Inter-American program, I keep doing it because I somehow believe that even the goals that seem to loom too large in my U.S. classroom are not just possible, but even perhaps pale in comparison to what I believe could be possible when teaching is connected to social movements and social struggles. In that space, there is a transformation that occurs that comes from feeling and human connectedness to the people, to the place, and to the struggle. Of course, it does not occur in every student, but I do sometimes experience those moments that are just as sweet as when Chris Blakeslee's daughters open their eyes to realize the beauty of Monet. And when this transformation occurs, I think I can aspire to believe that teaching cross-cultural competence could mean more than the development of skills to to allow you as lawyers to be more effective in pushing the client's interest, and also include the development of humanistic values that considers the ethics of fairness and respect for others when lawyering. Thank you.
Pleasures of coming in the last panel is that one gets to benefit from everyone else's contributions and the discussion that precedes. And we were asked to address, among others, how important it is for students to understand the role of law in a particular culture. And I think that so many of the contributions so far have addressed that question. And in particular, we saw the importance of the cultural in Donald Horowitz's presentation yesterday. He really illustrated what the larger society means to law, since constitutions, like all other law, are entirely contextual. And then I think many of us who have come after Hadide's original comments have been responding to her. I'm so sorry she's not here now, but really when she was talking about what was missing in her first year as a JD student in America, and then later in what I would call her search for comparative law, it's what I think of as, and what I called in an article I wrote, cultural immersion. And let me say that in the early 1990s, I thought it was important for comparative law to address the question of the role of law and culture from a theoretical standpoint. And this was the time when American law schools were just beginning to lose the generation of the émigrés who had brought comparative law to America. And I might just mention that with the death this year of Eric Stein, we have lost the last of the émigrés who was trained in law in Europe, and then got his JD degree in the United States. These people who had the dual training in law from both Europe and the United States brought something very special to their understanding of comparative law. And so, of course, they were retiring. By the early 1990s, many were beginning to retire already. And I guess, was it mid-1990s, Rudolf Schlesinger, for example, went to Hastings from Cornell. And so, so this was about the time when it seemed like what they were doing often effortlessly and perhaps to some extent unconsciously, we comparatists who were trained in one legal culture were going to have to consciously think about and theorize about if native-born Americans were going to be able to continue to do a good job, essentially. So the role of culture in understanding foreign law loomed very large in all of this. And if I look back at the 20 years or so that have passed since then, it seems to me that in our field, the role of culture has become so well established, so well recognized among us, that it's a battle that doesn't need to be fought any longer on a theoretical level. I don't really think that there are too many comparativists today who would say, well, you know, I don't think that this is important. We can just read the law in a foreign language or translation, and that's it. And you look at the text, and there's no need to look at it in context. They may not do it as well as some others would think is necessary, but still, I think on a theoretical level, that battle has been won. On a practical level in those years, there have been many surprises for me. I would say, first, this surge in international comparative law courses that exist today. Wow, I never expected it. In my career, I've been amazed from the beginning when one allowed me to teach this weird course to what goes on today. This has been a great change. But maybe the biggest change has been the surge in hirings of foreign-born lawyers in American law schools. Not all, I have to say. When we try to hire somebody, not in comparative law, but in a substantive field form somewhere else, my goodness, the struggle over, well, will she be able to teach torts? She hasn't been term fair. But anyway, still, the surge, when you look around in American law schools, amazing. So we now have all sorts of foreign-born lawyers with a native understanding of foreign law, able to teach us foreign law to our students. Unforeseen at the time. So, of course, legal culture remains a crucial topic to discuss in the sense that it itself is anything but static. It changes all the time. It's more than ever now influenced by what lies on its fringes, on its periphery, as well as in its center. And I thought of this when I read recently that Anthony Burgess praised the English language for its plasticity, for having had the genius, as he put it, to be as ready to yield to the netek as to the racially pure and grammatically orthodox. So while I don't think we need to argue to each other why it is that culture matters to law, we of course need to be teaching law in its culture. And I was struck by a recent decision of Judge Posner, I don't know how many of you noticed this, in which he says that he does not think we need experts on foreign law. He thinks that they're useless because they're hired by the parties to say whatever the clients pay them to say, and so the judge is confronted by two supposedly native contradictions of what the foreign law is now. The problem, of course, is extremely real, but his solution is, well, as long as it's not a law of a country where there are no translations, I'm just as capable as a judge of figuring it out as they are. Why should I listen to the experts? So I think the problem is very real. I think the solution is no solution, because he is not going to be understanding it in all likelihood in its context. And the fact that he even says that already says enough. So one of the specific issues that our panel was asked to address is the usefulness of teaching foreign law in a relevant language. So we're asked, for example, can comparative law be fully understood without reading materials in the language of foreign nations? So first of all, I think the question to ask is, well, how well would it be translated? Translation is, a lot would depend on that. Translation is a whole area of comparative law itself. Our journal has, by the way, had many interesting articles on the subject over the years. At least I think we can say law and language are so deeply interconnected that surely it's a good thing to read it in the original if one can. But reading in the original also doesn't mean that one will get necessarily the flavor of the original if one doesn't know the language really well. I mean, none of these things are a simple matter. So this semester, I'm teaching a course in international arbitration in French, and I'm doing this to a highly motivated group, so it's a great deal of fun. It's the first time that I've taught a substantive law course in the U.S. that's not in English. And I'd say that the primary advantage of teaching such a course is that it's a great shortcut to the legal culture. And I think it sounded to me like that's what Matthias was trying to suggest in his advocacy of teaching comparative law in substantive law courses as opposed to in the core course. I also teach a core course of comparative law, so I'm not adopting his suggestion, but I'm doing this in my international arbitration course in French. And I thought that he was also talking about the idea of the shortcut. So a major source of readings in the class that I'm teaching now is the Paris Journal of International Arbitration, the Cahiers de l'Arbitrage. And for example, in an article that we read about the domestic French court's resolution of a jurisdictional conflict between the private and public law courts, where one of the parties was a public entity, the term competence judiciaire, so I say this just for those of you who may speak French, was used many times. And this term indirectly, very indirectly, made clear that by contrast, the public law Supreme Court is not really a court technically, it's a council. So just some term like that allowed me to get in a lot about the French judicial system and many terms that the students don't fully grasp. They can't be clear in the context of the article that they're reading given the case that's being discussed, are an opening to talk about a whole legal system, a whole legal culture. So in that sense, I think of it as a shortcut. Many things that are unknown to the common law come out that way in the class discussions. So this is an area, namely international arbitration, that is truly transnational. So it could be taught fruitfully in any number of languages, and certainly the first language of international arbitration today has become English. The second language is French, so I think there's a good justification for teaching it in French. In any case, it could be taught in any number of languages. But these French articles in scholarly journals that we are reading certainly convey an enormous amount of information beyond the ostensible subject of the article that one reads. Now, one of the advantages of an area like international arbitration is that if one were to teach this and discover, as I thought I might, I didn't know what level of proficiency my students would have. They had to speak French well enough so that they could understand the level of French, of a French law school, because it was going to be taught in French that way, and they had to be able to understand readings that would be sophisticated. They had to be really fluent. But nevertheless, I didn't know how fluent they would turn out, and I really wanted to have this class, so I thought, well, you know, what compromises will we make? Well, so one of the things I did is I chose articles that were in French, but that often discussed arbitration cases where the cases themselves had been decided in English. So I thought, well, if they don't understand the articles so well, maybe they can read these original cases in English, and that will give them a clue as to what the article is more or less about. Luckily, it didn't turn out to be the case. But there would be many ways of adapting such a course to an American law school. And one of the things I think would be a great idea for us to do, those of us, because I noticed in the survey that there are now many schools offering law courses in foreign languages, somehow shouldn't we have some way of interacting with each other, exchanging ideas, what works, what doesn't work, what are the options? I think this would be very fruitful, and maybe we could expand the offerings of foreign languages by encouraging colleagues in law schools to do this. I do think it's a great idea. My students are so motivated. In the field of international arbitration, for those of you who don't know, at Sciences Po every year there's a terrific contest. If you have students who have any chance of winning, the winning team gets an internship at Clifford Chance for 6 months in Paris. I mean, my students are dreaming. I know we won't win because Paris one always wins, but anyway. Still at all, I mean, this is just great, and it's so much fun. So, and the students are so enthusiastic. They, you know, our students are so eager to have a transnational legal career. Not so many. I have just 6, but they're the best students in our law school, I think. So, and the other thing is the other reason I do it is, you know, I think a little bit of what Raquel was suggesting and what I heard also from Donald Horowitz is just maybe a little bit of a counterbalance to what Horowitz called the excessive pride of somehow the typical United States attitude one sees, you know, everyone speaks English, only English. So it's maybe a bit of an exercise in humility for us to speak a foreign language. Maybe it's not the native language, especially for students where it's not the native language. I regret infinitely that our school system from age 6 on doesn't do more with our children. The real thing we all need to do is join the school boards and try to change the way languages are taught. Law school is really a late stage, but let's do what we can since that's where we are teaching. So I also, as was mentioned, have started in the law school a program to teach languages in a legal context. I wrote a book called Learning French Through the Law, and the Spanish course we teach use that, and it's very easy to use that for Spanish. But we now have German. We're going to start Arabic for lawyers this next semester. So we have expanded it to other languages. And the idea there was also to hope that as much legal culture as possible would seep through the legal vocabulary. I have these little dialogues for French, at least, where that I used intentionally words that are cognates of English, like an innocent, innocent, etc. And almost everything had glossaries to translate, so you can really have absolute beginners. But still, you just have these beginning dialogues, even where the way people address a lawyer, you have a lawyer and a client. The word for client is client, so it's exactly the same as client. But they say maître to the lawyer. I mean, you just don't say that in English, anything like it. Can't translate it. As you were suggesting, the untranslatable. But so at least maybe a little bit of the legal culture comes through. So teaching a substantive law course in a foreign language, I would say, intensifies all of this. There also are hurdles. Faculty who think it's absolute nonsense to do this. I had a little bit of trouble getting my arbitration class through the curriculum committee. And deans who may need to be convinced. So these are issues that I would leave for the discussion period. I probably have used up my 10 minutes.
Do not think I actually know technology. My daughter helped me put this PowerPoint. I am the caboose. I'm the very last speaker. For those of you who know kids' books, I'm going to be the caboose that got loose. Just a quick background. I'm not on the executive anymore since I moved to Australia and left being employed by a member institution. And was very thrilled that you all voted to allow me to continue my relationship while I'm overseas. Legal culture is really the topic of today's panel, and yet as you can see from the title, I'm actually going to go, as I said, I'm going to get loose, I'm going to go in a different direction. Though legal culture, I think as Vivian suggested, it's something that we don't really need to argue about. I think we all accept its legitimacy. For me, legal culture has come into my teaching actually through my scholarship in the last few years. That's the area that I've focused most heavily on legal culture. Though the next edition of the casebook, which will hopefully come out before the other West casebook, will have more legal culture in it, which will reflect some of this work that I've been doing. So I'm going to briefly discuss legal culture, or culture. I don't think I need to talk too much about it, but culture leads, in my view, immediately to curricular consequences, which was also part of this question that we were asked. And then that leads, in my opinion, to systemic consequences for the fields at large, for comparative, transnational, international law. And I'll get to that. But let me just run through the questions that we have that's in your program at the beginning, so I can dispose of those. The questions, I'm not going to talk about language. It's not my area of expertise, though I absolutely agree with everything that was said earlier. One of the questions, can students truly understand comparative law and legal systems without immersion into the broader cultural framework within which laws and legal systems operate? Clearly, no, they cannot. How important is it for students to understand the role of law in a particular culture and attitudes towards law within that culture? Very important. I'm getting through this pretty quickly. I am, after all, the caboose here. Does introducing foreign language and cultural frameworks move beyond the competence of the law school? Language, as has already been talked about, though, I have to say that the linguistic incapacity of American students, in fact, of Anglophone students around the world, not just America, perhaps not Canada, but it is certainly a problem in Britain and a problem in Australia as well, and probably New Zealand, though I can't speak for New Zealand. So it is an Anglophone problem around the world. And then this question, which I really wanted to focus on, which is in the program, might there be significant advantage found in using a broadly conceived comparative law curriculum as a wedge to develop intercultural competence for attorneys expected to practice in an area of increased globalization? That's more where I'm going to go. My answer is yes, but I would not describe it as a comparative curriculum so much as a transnational curriculum. I think we're being too narrow, staying within the world only of comparative law. Let me give you the first slide to show that, in fact, even though we have agreed, I'll just do this. Even though we all feel that we know legal culture, we know about culture because it's the area within which we teach. You can see that perhaps we're not as comfortable with different environments as we might think. Of course, we'll all recognize this as the Earth. And this is a map which is absolutely valid. Right? Einstein was one of those that suggested there is no center to the universe. There's no absolute point from which all references can come. So let's use this as our map of the world. I actually had wanted to have one where Australia was in the middle, but the resolution wasn't as good. So I'll just have to work on this. And I personally find it hardest with this map to actually to see Australia. The U.S. I don't have a problem because it's nicely framed by Alaska and by Central America, and I can find it. But Australia just seems all wrong to me. I don't know. It must be something to do with my culture, I suppose. So it's possible that you can see that even we, comparativists, may not always be too comfortable outside of our normal framework. And culture, and legal culture in particular, is, I think, outside our colleagues' usual framework, right, within law school, even though it needs to be taught in all subjects. How can you teach contract without talking about the culture and the legal culture within which contracts work? Of course, the best classes will always include something like that, the context within it. And we often rail against our colleagues for not including a comparative legal context, a comparative legal cultural context as well. And yet, culture is problematic for lawyers. I actually think that we need to, as legal scholars, as legal teachers, we need to stick within legal culture. I think that there's something to be said about culture in general, but I'm not sure how many of us are actually competent. We're not anthropologists, we're not sociologists. Is this a call to include sociologists and anthropologists within the law school framework? Yes, I think so, but that's a larger matter than I want to go into. At the moment, I'm going to stick just with law professors, law scholars, even though I admit that culture really probably requires much more. So I think we need to stick to legal culture. What is legal culture? Well, legal culture, as I define it, and I felt quite comfortable defining it for myself in my recent scholarship, I say legal culture consists of those cultural characteristics present in and tied to a legal system, reflecting the common history, traditions, outlook, and approach of that system. Those characteristics may be reflected in the action or behavior of the actors, organizations, and even of the substance of the system. But then critically, legal culture exists not because of regulation of substantive law, but as a result of the collective response and actions of those participants in the legal system. And this is particularly difficult because it doesn't, in my opinion, generally exist because of substantive law. It happens because of our collective historic and traditional responses that may come out of the larger culture, but we don't even need to go that far in order to find legal culture. So the question is that legal culture relevant to the practice of attorneys? The transnational practice. Well, that was talked about yesterday. In fact, to me, it seemed clearly it is relevant. But it's relevant, I want to suggest, in a way that hasn't been talked about already. I think that it's relevant in the larger courses and what should be the curriculum to train people in transnational practice. I think that the legal culture that we as comparativists are comfortable with needs to be brought into transnational law courses, into public international law, into international economic law. Khadija yesterday mentioned that her colleagues in international economic law aren't really using this. She's generally right. There's a few, myself included. There's probably about 4 or 5 that I know of that are presently working to bring comparative law techniques and in particular legal culture into it. But I think it needs to be brought in much more. Our colleague, we need to speak, we're used to speaking to our contracts law and torts law and property law people and telling them, you must include transnational work, you must include comparative law. But we should be speaking to our public international law people as well. We should be speaking to those people that go to ASIL and asking them, why isn't there a comparative law section at the ASIL? Why might, and Vivian was just talking about this, why might comparative law papers have problems being placed in international law journals? To me, this seems an artificial division, which takes me to the, I have slides with text, but I've decided text is boring, let's go straight to the paintings. This is, some of you might recognize this, is actually a picture of the Tower, a painting of the Tower of Babel, a very famous one. And just as a side note, architects or engineers who looked at this painting have suggested that it was painted in such a way that it was in fact architecturally not possible. It was not going to reach God because of the way the arches are. It was going to collapse because of human error, which is itself a critique on the original story, which I think adds generally to the whole idea. Why do I put the Tower of Babel up there? I do that because I think our field, and I think we are part of this field, of transnational, public international, international economic law, comparative law, comes from this one area of non-domestic law, which is a lousy name for it, but from non-domestic law that has now split off into all these specializations. And now why is that relevant to legal culture? Because I think legal culture needs to be included solidly within it. How can you teach international business transactions without including legal culture? Public international law, well, we know that they use comparative law to identify principles and occasionally customary international law, like it was talked about just yesterday with reference to the Italy versus France or Germany case, which, by the way, is at the heart of the Jessup problem this year. In Australia, we're already well on our way to sorting out the Jessup problem. So it's relevant, but it's relevant at a deeper level, too. Some of the work I've done where I look at the WTO Secretariat and their legal culture and how that affects WTO decisions and WTO negotiations. We should be in there, the comparatives with them. They should be coming to us. So at a larger curricular level, and actually I would say at a systemic level, you know, we talk about what is this comparative law? We have trouble identifying what it is. That's because it's part of something larger. And we're trying to create something that is artificial by taking out that which deals with legal systems and legal traditions and legal culture, and we just deal with it in comparative law. But we can't. It is essentially non-domestic. And that can't exist without transnational, without public international law, without all the other fields that are out there. But that's hard. I mean, we already know how hard it is to be a comparative lawyer. I mean, to be a comparative lawyer, you must know everything about your own legal system. Well, that's almost impossible. You must then, if you're going to specialize in one foreign system, know everything about that foreign system, its history, context, all the different bits, because everything fits together. Well, you can't do that either. And if you're not going to specialize, and even if you do specialize, you still need to know about the other systems, right? Because otherwise, this work that was talked about the other day, I think that Frank had mentioned where he had done some work on, if he'd have known about other areas, it would have been better. Now we need to know about every legal system in the world, its history, its context, where it's going, and our own. This is almost impossible. And now I'm suggesting that, in fact, you need to know also about public international law and transnational law and international business transactions and international human rights and all those other things. Well, it's asking a lot. But part of the problem may be that we break everything down, that everything's too specialized. You know, it's like the Tower of Babel, all the different languages, though now with English perhaps it's in the process losing something, coming back together. and of course something could be lost. So what I am recommending is we need to rethink our breakdown of subjects, our relationships across institutions, across fields, and legal culture is actually the thing which shows that this is necessary, because it exists across all of these fields, and it's obviously so important. So just to end on, and then we were asked to be controversial, so I'm suggesting, I'm following Matthias said, we need to work as ASCL with others, which is already happening, but maybe with ASIL. ASIL needs to work with us. We need to work with our colleagues in transnational. We need to rethink what we're doing. And this, by the way, is already happening. The mandatory courses in many of the universities around the world for our non-domestic field are being called things like global law, or the one I have to create one at the University of New South Wales this coming year that we'll probably call law in global perspective. It's not comparative law. It's not international law. It's everything together so the student has at least something when they go out there into practice. Because they don't just need comparative, they don't just need public. They certainly need comparative more than they just need public, I would say that. But they need it all brought together. And that's a tall order. And so, jumping to the very last slide on which I'll end, and on this, we need to become Renaissance men and women, which is, of course, clearly very, very difficult. It's time-consuming, but I think it reaps all sorts of rewards for us in our scholarship, for the fields, for the students, for the practice, and it is, in fact, the direction that we're going. So I'll end with a little picture of Leonardo da Vinci, the ultimate Renaissance man, who I'm sure knew comparative law, public institutions, transnational litigation, and all those things. All right, I'll end there. Thank you.